Right out of the gate, this case is already packed with tension, and it's only going to escalate from here. We've got a defendant facing a serious allegation, failing to appear in court. Now, that might sound simple, but legally, it's a big deal. The judge is laying out the stakes: jail time, heavy fines, and even revocation of bond. But here's where things get interesting. The defendant seems to believe this was all supposed to be resolved already, almost like there's been some kind of misunderstanding behind the scenes. And that disconnect? That's where courtroom drama thrives. Because while the court operates on strict procedures and records, the defendant is operating on assumptions and possibly misinformation. As we move forward, watch closely how the judge handles this balance between rights and responsibilities, and ask yourself, if you were in this situation, would you trust the system or question everything like this defendant is about to?
No. Okay, you can answer my questions.
Sure.
Are you saying you want to represent yourself?
They have been doing that the whole time.
You've been doing that the whole time. Under Feretta v. California, 1975, U.S. Supreme Court, defendant has the constitutional right to represent himself. He has, in this case, unequivocally asserted that right in prior hearings and validly waived his right to counsel. However, self-representation may be denied where the defendant disrupts, unduly inconveniences, or burdens the court and the administration of the court's business. That's 1976, Michigan Supreme Court, People v. Anderson. Even the Feretta case, the U.S. Supreme Court said the right of self-representation is not a license to abuse the dignity of the courtroom. Neither is it a license not to comply with the relevant rules of procedural and substantive law. Here, while representing himself, defendant refused to accept mail from the clerk's office. When that happened, I directed staff to resend the mailing directly from the court, giving him the benefit of the doubt. Because he was representing himself, he would surely accept something from the court. He again refused, writing in red lettering on the envelope, "Return to sender, and offer to contract is denied." Defendant had someone file a document on his behalf in his case called a letter rogatory for relief, which was legal nonsense, accusing the court of fraudulently using this case as some sort of security against his trust, claiming that all judges are foreign agents and or employees of the International Monetary Fund, which is absolutely absurd, and demanding that he be placed on some non-existent do not detain list. This is not the first time that this defendant has disrupted this court's business. One time I had to hold Mr. McLoud in contempt for refusing to answer my questions during his initial waiver of counsel. After that contempt, we were able to complete the waiver process and I allowed him to represent himself. But at those subsequent hearings, he repeatedly interrupted the proceedings. He repeatedly persisted in arguments, even after being heard.
This is the turning point. And honestly, it's where things start unraveling fast for the defendant. The judge is doing something very important here, acknowledging that yes, the defendant does have a constitutional right to represent himself. But, and this is a huge but, that right is not unlimited. The moment self-representation starts interfering with the court's ability to function, the judge can step in and shut it down. And based on what we're hearing, refusing court, mail, filing bizarre legal documents, making disruptive arguments, it's clear the judge believes that line has been crossed. This isn't just about legal rights anymore. It's about courtroom control and respect for the process. So here's the big question for you. Should someone lose their right to represent themselves if they misuse it? Or should that right be protected no matter what?
Schedule this for a docket call on the underlying case, which is still pending, and on the contempt hearing. I'll schedule that for August 20th at 10 a.m. I also have to advise you, Mr. McLoud, that I canceled your jury trial date and gave that date to somebody else who was here. So your trial on August 8th and 9th will not occur. I will next see you on August 20th at 10 a.m. Anything as to release Mr. Varga?
Is the court wanting to entertain a bond on this matter, Your Honor? It's my understanding Mr. McLoud is a local resident and he has met, with the exception of the last court date, that he tells me that he thought the case was resolved, although obviously it was not. He has appeared for most of his prior court dates. Okay. and he's employed locally, Your Honor. I think perhaps if the court would set a modest monetary bond, that would ensure future events.
I will not have to do. I assure you.
Mr. Juliet?
And I would ask that bond remain revoked. He is, what I'm told, rejecting the court's mailings of the notice to appear. I mean, I think that's just a blatant violation of
Can I speak on that?
the court rule. So he's made it clear he doesn't want to take it as serious. I would ask that bond remain revoked.
All right, Mr. McLeod, is there something you wanted to tell me?
I wanted to speak on that, the mailing stuff. I do that with all my junk mail, and I'm really sorry if that happened to one of your letters.
Don't make it worse by lying to me right now, Mr. McLeod. You wrote clear things on that mailing that indicate sovereign citizen types of defenses that you thought you were asserting. It's not that this was junk mail. Don't make it worse. Don't make it worse by lying.
I apologize to you for maybe listening to some of the wrong information when I don't.
Well, you're a grown person, Mr. McLeod, and I hope you're learning an important lesson in civics.
Can I just say this?
You said what you wanted to say.
Before you make your decision, can I say this? I have a job right now that's completely exposed to the weather. I've got $40,000 worth of windows coming this week to this job. I really invested in this job, and my client really does rely on me. This would be a really big problem if I get this revoked at this stage.
All right, well, Mr. McLeod, it's a shame you had to learn a civics lesson the hard way here. You are a citizen with rights and freedoms, but you also have responsibilities in a society where other citizens
And
live
just
alone.
like that, this case reaches a powerful conclusion, with consequences that hit hard. The judge didn't just revoke the defendant's right to represent himself, but also remanded him into custody. Why? Because from the court's perspective, this wasn't just confusion or a simple mistake. It was a pattern of disruption, refusal to follow procedure, and what the judge clearly saw as a misuse of the legal system. The lesson here is crystal clear. Rights come with responsibilities, and when those responsibilities are ignored, the court will step in decisively. The defendant's arguments, including those tied to so-called sovereign citizen beliefs, didn't just fail. They made his situation worse. Now we want to hear from you. Do you think the judge made the right call here? Or was this too harsh? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.